Okay, good evening, everyone. I'm happy to chair today's last, but not least, session. It's called Living with the Past, Decommunization and Transitional Justice in Central and Eastern Europe. And we will have three great speakers in this session. So I will give the floor now to Dr. Jacek Sokołowski. He is a graduate from Jagiellonian University Faculty of Law. In 2005, received his PhD degree at the University of Heidelberg, and since then he has combined legal practice with academic activity. He's mainly interested in mutual interdependence of law and politics, especially lawmaking process. And today his topic is grappling of legislature with the judiciary over decommunization and lustration laws, evidence from Poland. So Jacek, the floor is yours.
Thank you very much. Good afternoon. It's a great pleasure and honor to be here and speak on some aspects of the Polish transitional justice process. Just final check. I have no dogs, contrary to Professor Zoll. I have one kid. I locked her in a bathroom, so it should be okay. Yes, we could shorten the name of this paper to the question: who makes law? Because the question of lustration and the way it was proceeded in Poland is a typical, very clear conflict conflict between the legislature and the judicative and the judiciary. It was at the end of the day the judges who decided the scope of lustration, and that was at one point that were at one point the judges who effectively stopped the lustration in Poland. But let's start from the beginning. I will use a well-known metrics formulated by Roman David in 2012 in his famous book. That the policy towards overcoming the past, or what the Germans called Vergangenheitsbewältigung, which is a very nice word, and I think it's a word which gives well the meaning of the problem. We have several factors shaping what could be called the Vergangenheitsbewältigung policy, and we have three different models which eventually come out of these factors. But first, I would like to ask the question whether overcoming the past actually could be treated as policy at all. Perhaps in some few cases it could, but mostly in most of the transition processes which I know, it was hardly controllable. The countries which underwent the process of transforming from dictatorship, from authoritarian or totalitarian regime towards democracy, hardly controlled their public policy, very least in this particular aspect. So I believe overcoming the past in most cases is rather a process which the political actors try to control, try to influence, but hardly can control it fully. And well, back to the factors. David noticed that 4 or actually 5 major factors play a part. What was the regime type? What was the level of repression? What scale of human rights abuses took place in a particular country? To what extent is the country politically divided? What are the people's opinion on current politics? It has great influence on the outcome of this Vergangenheitsbewältigung process. What was the regime lifetime is important. The longer the regime lived, the more people got used to it, the more positive sentiment towards various aspects of the regime could live within the society. That's the fourth factor. And finally, the fifth factor, which I didn't put in the presentation. I don't know why, actually, I missed it. The fifth factor is the transformation model. There were various ways of leaving the dictatorship and moving towards democracy, and it is well known that the Polish model was the negotiation model. There was no revolution in Poland. There was a roundtable compromise upon which the Communist Party lost power in a gradual process, which secured for them quite a prominent position. Well, it secured them a position in Polish politics, first of all. Any idea of decommunization was impossible to implement. It was hard to come up with the idea of decommunization as a real political project, because the post-communist party managed to establish itself very quickly as a fully legitimate competitor within the political system, which was still in statu nascendi, still being created, which was in Poland very important. Therefore, it is difficult to qualify the outcome according to the Roman David model. He identified three basic models of overcoming the past. The inclusive model, which is based mostly... Oh, sorry, I got it wrong. I'm very sorry, this slide is wrong. The exclusive model is based on dismissal and retribution. Exclusive model means that the people who are engaged in the former authoritarian regime are being dismissed from politics, and they have to deal with a certain amount of retribution, more or less under control of the law. Which means we could place Czech Republic or the former German Democratic Republic, the communist German state, into the exclusive model. The communist officiaries, functionaries were dismissed from politics. They were formally prohibited to enter public offices for a certain period of time. Then there is a inclusive model, which is based on something David called exposure. Exposure means a variety of measures, variety of policies which are aimed towards exposing the crimes, the atrocities of the regime without actually punishing these atrocities. So it formally could include lustration. I have several doubts about it. I will come to that soon. And the third model, the reconciliatory model, is based on confession, so on mechanisms similar to that which found place in the Republic of South Africa, when, to a certain extent, functionaries of the regime were granted pardon only in exchange for confession of their wrongdoings. As I said, it is hard to fit Poland's history exactly into one of these models. It is somewhere between the exclusive and inclusive model, and it is not entirely reconciliatory. And in my opinion, it's the effect of it's the result of the fact that there was no overcoming the past policy in Poland. It was never a controlled or steered policy. Not to at least it was planned. It was a process which, to a great extent, was not planned. And now let's get right to the middle of the story. For several reasons, mostly because of the strong position of the post-communist party, decommunization was not possible to enact, was not even possible to be proceeded as a political project. Mainly for that reason, the problem of lustration became a central political problem of dealing with the past. One could say that lustration became a substitute of any other measures directed at dealing with totalitarian past. And finally, in 1997, so quite late, after failed attempts to perform lustration in 1992, for 5 years nobody wanted to touch the subject. Finally, in 1997, first so-called Collaboration Act has been created by the Parliament. And this act created a very strange model of lustration, a model which became a source of future problems with lustration in Poland. Formally, as I said, we could say that putting lustration maybe putting so much focus on the lustration belongs formally to the exposure model. But for many of the members of Polish elite, and not only the members of the post-communist party, for many members of the post-solidarity parties, for many members of the elites of the establishment, of the media establishment, many people treated the mere fact of exposing somebody as a Secret Service collaborator as a form of punishment. Therefore, at least for part of the society, lustration as such was a form of retribution. And I believe it is because of that feeling, because people were convinced that exposing somebody's collaboration with the secret communist police is a punishment, the first Lustration Act implemented this strange procedure of revealing these facts. The person in question was obliged to make a declaration whether he or she collaborated or not. And this declaration should be verified by a court, by a lustration court, whether it is true or false. And should the declaration turn out to be false, should the court come to the conclusion that the lustrated person lied about her past, the quasi-punishment was supposed to be exclusion from participation in democratical game, the formal prohibition of entering public offices for 10 years. The clue of the entire construction was that the lustration court was supposed to verify the declaration according to the criminal proceedings code. So the person was to be treated quasi as a person in criminal proceeding, and the judges in the lustration court were all of them criminal judges, people who were specialized in judging the criminals, which led to a certain phenomenon which I would call the subjectivization of the prerequisites which were formulated in the act, in the provisions, because the provisions seemed very objective. The provision, the crucial provision, stated that a person should declare whether he or she was or was not a collaborator of several secret services of the Polish communist state. This sounds very objectively, but as a matter of fact, it is not objective, because the problem of collaboration with secret police, as it was named in the provision, was completely separated from the question and from the idea. One either was a collaborator or was not. But the criminal judges thought in these categories of guilt. Somebody cannot be accused, sentenced for a penalty if he commits a crime. He cannot be sentenced if he was not guilty. So the judges sought, I would say, a substitute of guilt. They had the feeling that they cannot declare somebody a lustration liar only because there are formal arguments which speak for the fact that he was a collaborator, but that they have to find him somehow guilty. And they found this idea of guilt in the definition of collaboration itself, which I will try to show you in the next slide, if I manage to. Too much. Okay. First, there were many rulings, of course, of the Constitutional Court, because the lustration bill, as imagined, the collaboration as was attacked politically many times by various political parties, by various politicians, and the constitutional review of the act was performed many times. But three rulings are particularly important, so I've chosen them to show you how this process of subjectivizing the notion of collaboration was performed. In the first ruling in 1997, TK is the abbreviation for Trybunał Konstytucyjny, for the Polish Constitutional Court, has formulated some basic requisites. When can we actually conclusion that collaboration matters? Not every form of collaboration matters. Not every form of collaboration is enough. And it was this notion of conscious activities, as you see. It was not enough that somebody was registered as a collaborator, that he had a record in archives. There must be kind of proof necessary to find him a lustration liar, that he was collaborating consciously. This was a vague notion. It was precising to some extent the scope of what collaboration means, and it was narrowing it. It is worth mentioning twice Constitutional Court has protected the Collaboration Act from ruling it unconstitutional at the initiative of the Post Party, because of course Post-Communist Party tried to amend the act so to make it say toothless, to make it dangerous for people who collaborated with various forms of communist secret services. So first there was amendment which was ruled unconstitutional in 2002. This was a new definition of collaboration, which actually was so detailed that no collaborator would be capable of this definition. So this was first attempt of the Post-Communist Party to fight the lustration. The second, also in 2002, this was another amendment, collaboration with intelligence and secret and counterintelligence agencies of the Communist Poland. The idea, the aim of the deputies who have novelized Collaboration Act this way is also clear. The point was that the intelligence and counterintelligence agencies were also spying on the oppositional, on the persons within the opposition. So they were not intelligence exactly in these terms as in Western democratic countries. So first, let's look again what the Constitutional Court did. First, it has restricted the scope of lustration. It has required pretty clear prerequisites for finding that somebody was a collaborator. And then twice he stopped the attempt to block the lustration. We could say, I called it a policy, and I think it was a conscious policy. The composition of the Constitutional Court back then, at that time, was mostly of people who believed that some form of lustration in Poland is necessary, and that true lustration must find place, that some people who actually really collaborated with secret police should be revealed, should be exposed. But at the same time, they didn't wish that this process applies to too many people. They wanted to restrict the number of cases. And this is exactly what their rulings did. So far, so good. We could say that up to this moment, we have a Constitutional Court intervening into the state's policy, into the parliamentary policy, into the Parliamentary Act, changing a bit the way this act is enacted, narrowing a bit its impact, weakening a bit its impact, but at the same time protecting this policy from its foes. But then came the Supreme Court, and the Supreme Court did something entirely different. Supreme Court stopped the lustration at all. How it happened? There was a practice which grew gradually during the lustration processes, that people accused of being lustration liars, thus accused of being secret collaborators, have called upon witnesses to testify in their favor. And these witnesses were the former officers of the secret communist police. And these officers came to courts and testified various things, but basically they said that the collaboration was a fake collaboration, that the agent, the collaborator, actually did not tell them anything relevant, that he tried to avoid the collaboration. Even if he signed something, he was acting in a way which was not helpful for his officer. It was a very common line of defense, and in the first instance, lustration court didn't take that line of defense into account, found it not credible, found in general the testimonies of former security service officers as not reliable, as not credible. The lustration court stuck to the position, to the judgment that former security service officer is not a credible evidence, what he says, that he's acting in the interest of his source, so to say, that he's trying to protect his source. And the second instance, the appellation instance, have generally followed that line, and that line was eventually broken by the Supreme Court in this famous verdict, 2 KKN 271 in the year 2000. In this verdict, Supreme Court, basing on this notion of conscious activities, which was formulated earlier by the Constitutional Court, Supreme Court precised what conscious activities means. And it said basically that it's not enough that the collaboration was conscious, that the collaborator knew that he is speaking with a Secret Service officer. It's not enough that he signed obligation to cooperate. It's not enough that he delivered information. It's not even enough that he was paid for it. It is necessary, said the Supreme Court, in order to consider somebody's activity as conscious activity, that this activity was facilitating the activities of security organs, that it was actually helpful, that the information delivered by the collaborator was useful. Now, how can we prove that somebody who has a record, archival record, that he signed an agreement of collaboration, that we have his reports, we have confirmations that he received money? How can we now prove that it was useful what he delivered? Well, said the Supreme Court, the final evidence, the decisive evidence, is the testimony of the security service officer. If he confirms that the actually information was helpful, then it means that we have a collaborator. If he denies it, we have to trust him. The collaborator was a fake collaborator. And these are two famous notions formulated in the same verdict: fake collaboration and avoiding collaboration. All the agents, all people accused of being collaborators of the Secret Service, could say that they were, formally they were registered, they signed, they even got money, but actually they weren't delivering anything useful. They were deceiving their officer, so to say, and it was fake collaboration. And once this verdict was given in 2000, it was actually end of lustration. As you can well imagine, it became impossible to prove to anybody that he was a collaborator. Perhaps in rare cases when none of the officers were available to testify and the material evidence in the documents was very strong, then perhaps we could say, basing on these documents in the archives, that it was a useful collaboration. But in most cases it was not, and therefore lustration processes became a farce, because it was impossible to find virtually whoever a collaborator. Now, interesting is, of course, the question why Supreme Court intervened in this way, but this is perhaps a matter for another paper. It's a question of the relation between the judiciary and the communist system. And yeah, this is material for some sociological research. So I will restrict myself also with regard to the time I have at my disposal. I will restrict myself to the outcomes. And most important is because apart from this verdict of the Supreme Court, this verdict happened because of the views the judges in the Supreme Court had, but this verdict also was given because they had the power to give it. And they had the power to give it because of this peculiar construction of the Polish lustration model. It was regarded from the beginning as a form of retribution, not as an exposure. And therefore, because it was regarded as a form of retribution, the adopted model was based on the criminal proceedings code. Therefore, it was based on the basic rule that somebody must be proved guilty. This requirement to prove somebody his guilt was not in the act as such, was not formulated in the provisions, but it was planted, so to say. It was written additionally by the judges who were unable to actually proceed the situation in different categories because they were criminal judges and because they had the criminal proceedings code in their hands. And this led to a situation in which eventually the Supreme Court had grabbed this power of changing completely the notice of collaboration and thus effectively putting an end to the lustration. Of course, it was not the end of the story. The act was novelized later and the lustration went on, but I want to stop at this moment. Thank you.
Thank you very much, Jacek. It was a very interesting presentation. It was really interesting to listen to the Polish experience in regard to lustration laws and interpretation of collaboration. So now I will ask our second speaker, Dr. Miklós Könczöl, who is an associate professor at Pázmány Péter Catholic University and research fellow at the Institute for Legal Studies, Center for Social Sciences in Budapest. His research focuses on the history of legal rhetoric, theory of argumentation, and the semiotics of law. He currently works on Hungarian case law concerning the accessibility of Secret Service files from the pre-1989 communist regime. He is managing editor of the journals Intersections, East European Journal of Society and Politics, and Hungarian Journal of Legal Studies, Acta Juridica Hungarica. And today he's going to give a presentation with the topic Constitutional Review of the Hungarian Law Governing Accessibility of Data Concerning Collaboration with the Communist Regime, the 1990s case and its afterlife. So, Miklós, the floor is yours.
Thank you very much. Can you hear me right now? That's lovely, thank you. So yes, my talk is about my work in progress, which focuses on some constitutional court cases, and in particular decision number 60 of 1994, which actually was delivered on the day of Christmas Eve, so it's quite appropriate to talk about right now. It was on the Hungarian equivalent of what Jacek Sokołowski was talking about, the Hungarian lustration law, and thus give a premature end to this process in Hungary. And what I wish to follow here is, on the one hand, this story, how the focus of lustration has been moved from the actual political or quasi-juridical procedure to the access to information and the right to control information about oneself, which I think is very interesting. And also, what I hope to do later on in my work is to focus on the intersections between national history and private history, because I think this is what the real lesson of this story is from a theoretical perspective. So what I shall focus on today is on the one hand this particular decision from the mid-90s of the Hungarian Constitutional Court, and secondly a series of cases arising in the middle of the previous decade, which was then related to the publication of information concerning the activity of one particular person, allegedly at least collaborating with the Secret Service during the communist era. So the decision number 60 of 1994 of the Hungarian Constitutional Court, delivered on the 24th of December, finished the procedure related to a series of claims of unconstitutionality against Act 23 of the same year, on what was the title, on the review of persons holding specific important positions on the one hand, and on the unconstitutional silence, as they put it, of the legislature on the other. Now, the act, I shall refer to it as the Lustration Act of Hungary, was passed in the last month of the first freely elected National Assembly in March of the same year, and it actually appeared in the official gazette one month later. It came as the last in a series of attempts at the restitution or compensation of wrongs caused during the communist regime on the one hand, and in connection with that, at establishing the legal responsibility of those collaborating with the pre-1990 state authorities in the surveillance of citizens. The results of these legislative attempts were mixed, actually. While the material and financial compensation had its limits due to the scarcity of means, the moral compensation and the lustration of public and political life did not, in many cases at least, find a form that would be accepted against the rule of law standards applied and partly developed by the first Constitutional Court. Now, a notable case was another decision 11 of 1992, on a bill passed back in the previous year on the prosecution of crimes committed between 1944 and 1919. But I'm not going to talk about this today. Now, the Lustration Act aimed at the lustration of those holding specific positions in the public sphere, broadly understood. It provided for judicial committees, the so-called lustration judges, with the task of screening those concerned to establish whether they had worked for the state security services or obtained information from the latter to support their decision-making, or if they had been members of the Hungarian National Socialist Party during the Second World War. The Act provided for the procedural rules of the screening, authorizing the committees to request data from the registries of the Ministry of Internal Affairs and the Ministry of Defense. The outcome of the procedure in positive cases was twofold. The committee had to inform those found to be concerned by either of the above cases, and in case they did not resign from their posts, to publish their findings. The Act provided for no possibility to appeal against the decision. However, those concerned would have had to file a claim with the Metropolitan Court of Budapest. So there was a judicial review proper of those findings of the committees, but the members of the committees, albeit recruited from judges, from active judges, were removed from the judiciary for that time. The unconstitutionality claims were pointed at the arbitrariness of defining the posts that needed to be screened for instance, discriminating among those holding important financial and economic, religious or academic positions, or even among journalists, including some but not others, without any clear justification. Further claims concern the lack of clear procedure rules and the right to appeal, as well as the lack of transparency during committee hearings and also court proceedings. In addition to finding crucial parts of the Act unconstitutional just because of the discrimination among the sphere of those concerned, the court also held that the lack of legislation on the control of information of those mentioned in the files resulted in an unconstitutional situation. It should also be added that the screening conducted under the Act did not prove to be particularly effective either. Among others, the committee found that a former minister and later the Prime Minister of Hungary did cooperate with the state security services, and when later asked about that in a parliamentary debate, the politician famously answered, "So what?" So what we have here in the Act, and it is pointed out in the reasoning of the decision, is clearly a conflict between public and private interest. What is more interesting for us, however, how the focus has been shifted, partly along the lines already laid out in the decision. Because later legislation moved the issue of the issue in the direction already suggested in a remark of the court decision, towards the expert research of historical facts as opposed to the judicial decision-making. In that vein, the Historical Office, an archive of the Secret Service files, has been established in 96, which was then later transformed into its present form, the so-called Historical Archives of the Security Services, in 2003. With that, the direct aim of lustration has been abandoned, giving place to the question of information-related rights. While the 1994 decision already tackled the problem in terms of the right to those concerned by the screening to control others' access to personal information. In the new context of accessing information by individuals, there is now a threefold problem. Alongside the right of those collaborating in some form with the Communist Secret Service, there is the right of those under surveillance to obtain information on those reporting on them, and the related right of those third persons who are mentioned in the reports in some form. And thirdly, the right of those researching history, whose work then promotes public interest by making historical facts widely accessible for the members of the whole political community. Further legislation has repeatedly tried to strike a balance among these rights in dialogue with the jurisprudence of the Constitutional Court. I'm not going to discuss that in detail. I'm just mentioning that in particular the question of publication of facts has led to fervent disputes, not independently of the lack of lustration on the one hand, and indeed on the nearly complete lack of persecution of crimes against humanity committed by exponents of the communist regime. Moreover, while the right to what is termed information compensation seems to be undisputed in that dialogue, the question of practical accessibility remains. Given that surveillance was by its nature less than obvious for those concerned, it was in secret, people may not be aware of their data appearing in the files, and even if they are, they may lack the actual possibility to access that. However, it is facilitated by legal provisions and new technology. And all that directs the focus on the role of experts specializing in the field, whose scholarly research may have a key role in making the past accessible, both for the public in general and the individual holders of the respective information rights. And then I come the series of cases in the mid-2000s. In 2007, a Hungarian weekly paper published an article written by the prominent historian Cristian Ungváry on the measures taken in the 80s by the state security services against what was then considered to be a dissident student organization at the University of Pécs. Drawing on material accessed at the historical archives, Ungváry, the historian, discussed the role played by a certain László Kiss, at the time vice secretary of the State Communist Party chapter at the university between 1983 and 88, who cooperated with the security services. The person Kiss filed a claim against the journal, which was then upheld by the local court. Less than 2 weeks later, the historian, Ungváry, was interviewed by the national TV channel where he basically repeated his findings, adding that Kiss, who was then judge of the Constitutional Court, was the chief bastard in the story. In the next year, he published a co-authored volume where he republished his findings once again. Following that, Judge Kiss both initiated a criminal procedure against Ungváry because of criminal defamation and filed claims of libel and press correction against both Ungváry and the publisher of the journal. In the tort procedure, the latter one, the municipal court of Budapest decided once again in favor of the claimant, holding that most of the disputed claims were actually factual statements. In the libel case, the court similarly decided in favor of Kiss, holding that Ungváry and his publisher published unproven claims that would violate the claimant's good reputation. On appeal, the regional court ruled that the claims made by Ungváry were, in contrast, value judgment rather than factual statements based on actual facts, and thus declined the claim, while holding by calling Kiss a bastard in his interview, Ungváry actually defamed Kiss. On retrial then, the Hungarian Supreme Court changed the appeal judgment, apart from upholding the defamation ruling, and argued that the article infringed on Kiss's personality rights by making the false impression that he was an informer and a quasi-agent of the security services during the communist era and was an official contact collaborating with the services and reporting to them, as well as following their advice in objecting to the election of an officer to that student movement at the university. The court found these claims unfounded and libellous against the claimant, and Ungváry had to pay some 3,500 euros in compensation, and he and the publisher together had to pay the double of this sum together. In the criminal case, on the other hand, the local court found Ungváry guilty of defamation due to his use of the term bastard and chief bastard, while holding that his factual claims were based on scholarly research, thus belonging to scholarship only and under scholarly assessment. On appeal then, the municipal court also found Ungváry guilty of slander, arguing that his claims concerning Kiss were factual statements rather than opinions, and that Ungváry was unable to prove these. On second appeal, however, the regional court acquitted Ungváry on both charges. After a retrial, the Supreme Court upheld that latter judgment. Now, coming back to the libel case, following the final decision, Ungváry and his publisher filed a claim before the European Court of Human Rights, claiming that their freedom of speech has been violated by the domestic courts. With a less than conclusive reasoning, in terms of the classification of Ungváry's claims, the court held in favor of the claimants here. And it has been observed in scholarship that the courts did not apply a consistent standard, either in distinguishing factual statements and opinions or value judgments, or in following the ruling of the Constitutional Court, which they otherwise all quoted, in using the criteria of professional care, which would exculpate those making evidence-based factual statements. So here what we have is a very interesting line of development, shifting the focus from the original aim of lustration towards the problem of access to information. while shifting this focus basically opens up a new field of debate concerning information rights. If I would have some more time, I would go on with the post-2010 developments, which then basically repoliticized the whole issue, even in the absence of lustration. So from the field of memory rights, we are basically moving towards the field of memory politics in Hungary. But I have to stop here. Thank you very much for your attention.
Thank you very much, Miklós. It was an interesting and thorough approach from another country. And now we will move to the third speaker, Professor Klaus Ziemer, who studied history, political science, and Latin in Heidelberg and Munich. Received his PhD and habilitation in political science in Heidelberg. Was a professor of political science at the University of Trier. During that time, 10 years director of the German Historical Institute in Warsaw. Until 2018, was a professor of political science at the Cardinal Stefan Wyszyński University in Warsaw. And professors' fields of interest are transformation in post-communist countries, German Polish relations after World War II, and history policy. And today, Professor will present on DDR's legal injustice after Germany's reunification. Professor, the floor is yours.
With German unification in 1990, German society had for the second time the task of coming to terms with the heritage of a political system which had systematically committed injury initiated by the state. Having in mind that denazification after World War II had largely failed, German politicians from East and West were aware that a reasonable approach to the injury caused by the communist dictatorship of the GDR was extremely difficult. And not only because this dictatorship had lasted more than 3 times longer than that of the Third Reich. Coming to terms with GDR injury had several dimensions, some of which I'll discuss here shortly. To these dimensions belong penal-oriented politics, especially perpetrator-oriented penal prosecution. This concerns, for instance, murders committed at the German border. Victim-oriented politics, e.g. rehabilitation and compensation. Then documentation of and access to Stasi records. In no other post-communist society, the demand for access to one's own files in the records of the Communist Secret Service has been as high as in East Germany and continues to be on an exceptionally high level until today. Then decommunization of the state. This meant that all persons had to be screened who in the GDR had been active in professions under control of the SED. It's a very different approach from denazification. And finally, what is at the center of scientific research in Germany on totalitarianism after 1989? Germany's National Socialist past or the communist past of East Germany. So, and now I would like to change the file, but unfortunately I can't. Well, I'll continue with this file. After German unification, politicians and many representatives of civil society agreed that mistakes which quite evidently had been committed during denazification after World War II had to be avoided when coming to terms with the heritage of communist injustice in East Germany. 10,000s of victims believed, on the one hand, that perpetrators who had committed blatant injustice would be sentenced by courts. On the other hand, they hoped for a certain compensation for what they had suffered in prison or by other kinds of discrimination. The first assumption was almost made impossible by regulations of the Treaty on German Unification negotiated between the governments of the Federal Republic and the new democratic government of the GDR, ratified by both parliaments. According to this treaty, criminal acts committed in the GDR could not be sentenced after German unification because GDR law ceased to be valid. The application of West German law would, however, have been incompatible with the prohibition of a sentence without a legal basis at the moment when the offense was committed. The consequence was that de facto the perpetrators were judged according to legal regulations most favorable to them. In the end, there were about 75,000 preliminary proceedings against about 100,000 accused persons, but only 1,737 persons were really charged in 1,021 proceedings. Only a little bit more than half of these proceedings ended with a condemnation, mostly suspended sentences with probation or a fine. Most known were the legal proceedings concerning murders at the German domestic border, especially at the Berlin Wall. These murders were, according to the German Federal Supreme Court, not covered even by GDR legislation. But only some 40 persons were sentenced to prison. Sentenced were, however, not only soldiers who personally killed fugitives, but also the perpetrators behind the perpetrators, that is, high-ranking Politburo members who had signed the order to eventually kill people who tried to leave the GDR in an illegal way. Egon Krenz, who after Honecker was for a short time at the top of the East German Communist Party, received 6.5 years of prison. Former Politburo member Günter Schabowski and Günter Kleiber 3 years each. But the trials against many of the top-ranking party officials, beginning with Erich Honecker, were not finished because the accused were physically not able to assist at the trial. Erich Mielke, whose case was mentioned already here this morning, was not sentenced for what he did during more than 30 years as chief of the Stasi, but for 2 murders of policemen from the year 1931, because murder could not become statute barred. He received 6 years and was dismissed after 4 years because of his age. He was 88. And this was very good because he did not die as a martyr in prison, but when he came out, he had to notice that people hated him, asked him why he had done for the Stasi what he had done, and then he lived completely isolated. Given the relatively mild sentences against not only the top responsible politicians of the GDR, but also the rank-and-file members of the state apparatus who executed the GDR's injustice in everyday life as Stasi officers or in prison against political prisoners, one can understand the deception expressed in the often quoted statement by Bärbel Bohley, one of the leading GDR civil rights activists. We wanted justice and we got the rule of law. Panel prosecution concerned quite a lot of domains. I'll only mention two. For instance, electoral fraud. Egon Krenz was sentenced for electoral fraud of the local elections of 1989. And one thing is stopping. This is relevant until today. GDR sportsmen were very successful, but in many cases, because they were doped, often without knowing that, and many persons still are suffering from these doping. And these are cases which are relevant in trials until today. A second item concerns the rehabilitation of persons who had experienced unjust sentences given the GDR courts, by GDR courts. Eventually, such a rehabilitation was accompanied by a compensation for material losses a victim had suffered by not being able to gain income for the time of being arrested. In many cases, this affected also the retirement pension, and although the monthly amount of the victims has been raised in the meantime, in many cases, former perpetrators are receiving a higher monthly income than their victims. One of the main characteristics of coming to terms with the communist past of the GDR in United Germany is the open access to the records of the Communist Secret Service, in German Staatssicherheit or Stasi. The open access has been possible since to civil rights activists in East Germany, and this in two respects. First, they occupied the main Stasi building and safeguarded the records in winter 1989-90, when they noticed a suspicious smoke coming from the inside. This took place not only in Berlin, but also in several provincial towns where regional Stasi records were confiscated. At the second time, the civil rights activists protested by hunger strikes in summer 1990 against the intention of West German politicians either to destroy the Stasi records completely or to put them to the Federal Archive in Koblenz and keep them secret for 30 years. In the end, public access to the Stasi archives was written into the Inner German Treaty on Unification. A special office was created in Berlin where the Stasi records were archived. The German abbreviation for this office with a terribly long name is BSTU. Some similar offices were created in several regional centers. In some, the Stasi documents today amount to about 111 kilometers. One of the most controversial questions was who was to get access to the files and under which conditions. Some politicians, such as the last democratic prime minister of the GDR, Lothar de Maizière, were afraid that when people get informed about who denounced them to the Stasi, there would be a mood in the GDR like a civil war. And Joachim Gauck, a former Protestant pastor who had been responsible for the Stasi records already in the democratically elected parliament of the GDR and in United Germany, first head of the BSTU, he pleaded for an open access for everyone to the documents concerning her or him. Everybody should have the right to know the own biography completely. Self-determination on my own biography. Everybody should have the right to know the own biography completely. And when this happened, many people were, of course, disappointed when they learned that they had been denounced, for instance, by close members of their family. The churches were consequent in screening their staff on collaboration with the Stasi, and the result was a little bit shocking because several high-ranking, even Protestant and also Catholic members of the church had been unofficial Stasi collaborators, even two Protestant bishops. This was when this came out. Were of course bitter moments, but after some weeks, the atmosphere, the public atmosphere, became clear, and Stasi did not longer hinder the public life in East Germany. As compared to other post-communist states, one can't but be astonished about the demands. There were 3.2 million individual applications for access to the own documents. In 2017, there were still 49,000, and in 2018, 45,000 new applications. An important role the BSTU had to play in screening the staff of the complete public service, that is, active persons who were active in professions under control of the SED. A person who had been an official or unofficial Stasi collaborator was dismissed. Until 2010, the BSTU had to answer to 1.7 million requests in this respect. In this way, the problem, which in some post-communist states is called decommunization, was resolved in a relatively transparent way. It was a merit that Gauck and his staff had created an institution without example, which has been working very carefully and has relatively quickly gained the confidence of the public. This is most important to say that nobody who gets an answer from this office has the suspicion that there is a political implication or something like this. This institution has the reputation to be fair and has done quite a lot to clarify public atmosphere after especially the Stasi. Well, I see colonization. Well, there was one domain I should mention shortly, that is the universities. It was clear that subjects like Marxism-Leninism were abolished, but in other domains, like, for instance, history, West German professors, commissions came to see if the persons, to check if persons in office could qualify for continued work at the given university. This sometimes caused the reproach of a colonization of the East by the West, often exaggerated, but in some cases, a judgment made at the beginning of the 1990s would probably be milder today. Coming to terms with the heritage of the GDR was a self-evident task for historical research, not only in West Germany, but also in newly created research centers in the East, as in Potsdam or Dresden. A question which was put very quickly was, what should be at the top of research on Germany's experience with dictatorial regimes, National Socialism, or the communist past of East Germany? The the answer given by Bernd Faulenbach in 1998 is very often quoted. The Nazi crimes cannot be relativized by addressing to crimes of Stalinism, and Stalinism crimes may not be trivialized by referring to Nazi crimes. Given the relatively positive balance sheet of coming to terms with a Stasi record on the one hand, and frequent reports on right-wing attitudes and voting behavior in East Germany on the other, one might ask, what went wrong? One answer is that public discussion concentrated perhaps too much on the Stasi connections and too little about the importance of the Communist Party for maintaining the non-democratic system in the GDR. Another item is that quite evidently extreme right-wing movements, although rather marginal, but existing in the GDR, were not taken into consideration also after unification. So the balance sheet of coming to terms with the GDR injury is in sum relatively positive, but several dark spots need to be explained still. Thank you very much.
For closing the presentations session, and I believe sometimes it's an advantage of being the last ones, as it gives us a possibility to use at least a few minutes for discussion, although I understand that we have used all of our time. So maybe some of the participants would like to ask each other a question and to start a short discussion. Okay, Professor Arkadiusz.
Yes, thank you very much for those three wonderful presentations. I have a question first to Professor Ziemer. You quoted a very, I think, impressive in a way quotation. We expected justice, we received the rule of law. And I think it is quite up to date in the discussion in some countries, including Poland. Do you think that this tension or discrepancy between like the statement expresses, does it mean that somehow this legal notion of the rule of law failed? Or the opposite, it is the proof of how robust the rule of law was and it stopped the popular expectation to have justice at the expense of the rule of law? So this would be my first question.
No, I think in the end, the rule of law was successful. If we had judged according to different say what the civic rights activists attended, it would have been injury, and we have to accept that it is insufficient, and in many respects it is not satisfying what happened in this case. But the other way round would have been injury done by the courts, and therefore we have to accept this. and I myself am not satisfied with this, but I think the rule of law is strong enough now to be accepted by everybody, and to have give a solid basis to this state.
Thank you very much, Professor, for your answer. Professor Radovan, do you have a second question?
Yes, my second question would be to Dr. Jacek Sokołowski, but in a way also to the other speakers. But it is, I think, mostly valid for Poland. Jacek, do you think that the manner how judiciary curtailed the lustration laws in Poland had any effect on the confidence people of Poland have had in the courts in Poland, whether it had an impact, whether it weakened legitimacy of the judiciary in Poland? And maybe also
well, I think actually less than some politicians tend to believe. Because on one hand, there is this very strong impression that the courts in Poland compromised on the question of overcoming the past, and it was regarded by a substantial part of the society that there is something definitely wrong with the way the lustration is being handled in the courts, and in particular, even worse for the image of the courts and for the legitimization of the Third Republic. Worse was the handling of the processes, criminal proceedings of people who were responsible for crimes, for killings during the martial law in the 80s, because they effectively led to a situation in which everybody went unpunished after a long and not really serious criminal trials. But I think at the end of the day, so on one hand there was this part, and I think it was a minority who was disgusted, who felt rejection towards the courts, but more towards the state. I think it actually the eventual damage was done to the state itself. It's not so much that people were angry, so to say, at courts, because all the empirical evidence actually shows us that people were pretty confident towards Polish courts. They were disillusioned, or they were disappointed with regards to the time that the proceedings, the trials take. But people were not particularly, the empirical research shows no particular negative sentiment towards the courts as such. But there is another phenomena. There is this reluctance of many of the Polish citizens towards the state as such. And I think the Third Republic, and this is the true problem, was weakly legitimized because of the transitional justice it offered. But it went to the so to say, it went to the state as a whole, not courts in particular. I think what really matters from a longer perspective, because it's more than 30 years now from the transition, from the fall of the Berlin Wall, from the fall of communism in Poland. My remarks might seem pretty cynical, but at the end of the day, what really matters is the symbolic and long-lasting value of transitional justice. It is less important whether the justice was properly done in individual cases. Important is the final impression, the final judgment that the society builds up towards the communist totalitarian past. This is what is most important from the point of view of the integrity of the society, and for the way the politics works. Of course, it could be done better or worse. I think in Germany it was done better. In Poland it was done worse. But there's a certain paradox that in Poland this process of transitional justice, this overwhelming the past, was done, as I was also showing in my paper, was done in a particularly inefficient way. In a way which was compromising the idea, but still it helped, and in particular the the creation and existence of the Institute for the National Remembrance helped. And what was most important was the educational activities of the Institute of National Remembrance. The fact is, the majority of Poles now judges the communist past negatively. Nobody thinks in Poland, especially in the younger generation, that communist Poland was a nice and positive way of dealing with things, of organizing people's life. And it happened even though all those elements of the transitive justice were pretty compromised. So I think this is most important from the overall political, sociological point of view. This is important.
So if we don't have any more questions, I think that... sorry. Yes, Professor.
A last comment concerning the symbolic way. It was, for me, it was very important that the politicians responsible for killing at the Berlin Wall got higher sentences than the people who shot. That the perpetrators behind the perpetrators were sentenced, and not as in many cases during denazification, that at least this was reached.
Thank you, Professor, for your comment.
Well, which is of course in this moral dimension very important, and I think it helped the German society to reintegrate after the communism, and of course I'm personally I support that idea. But as I regard nowadays Poland, I think we came to terms with our past, more or less, even though these elements, which Professor Ziemer mentioned, failed. We did not have such a process, though we ought to have. So it is a question whether all the measures are necessary. I think there is one thing in Poland that we are missing, another cost. We are bearing another cost of the failed transitional justice or insufficient transitional justice. The state in which our society currently is, it is highly polarized. I would say that the political competition is highly decivilized and is based on delegitimization, mutual delegitimization of both sides. I think this is the legacy of our failed transitional justice policy. But not the missing rejection of the totalitarian state as such.
So I think that we can then call this discussion closed. And as I still have a chance now, I want to thank Professor Arkadiusz Radwan for a possibility to chair this very interesting session. And I guess that, and also the speakers for your interesting presentations and the discussion. And I think I'm going to pass the word now to Professor Radwan to say the final word closing the conference.
Aušrinė, thank you so much for chairing this session. I also would like to thank the other chairpersons, Professor Balcerzak, Professor Wyszyński, and Dr. Chorąziak, and all the speakers who represented many nationalities, many institutions, and also disciplines, because the topic of our discussion is the one that cannot really be approached by the methodology of one discipline only. If we want to have a fruitful discussion, the only way to proceed is to involve political scientists, sociologists, historians, philosophers, and lawyers. I myself, I'm a lawyer, and the very title of the conference is about juridification of history. So we borrow from other disciplines to look about where is the space for the law. Is there a space for legal governance of history? What are the limits and opportunities? And this discussion the conference comes to an end, but not the discussion. We look forward to continuing this discussion in the year to come, in the next year, in different formats, the smaller ones and the bigger ones. And as some of the speakers mentioned before, the goal is also to wrap up all these efforts with publications that will bring together those different experiences and sensitivities and so on. So I'm looking forward to working for you also in the next year. And I would like one more time to thank you all for contributing to this conference. I learned a lot. I think it was interesting. We made it eventually, even though it was not so easy in this online format, but I think we made it. So thank you for this. There are many more also legal problems that we could not discuss or not enough discuss today, like post-truth and fake news, how these new paradigms of the media affect the policy choices. Also, there are some administrative and private law questions, like, for instance, in Austria, where I'm speaking from, there is a discussion about Gusen and commemorating Gusen, and this area today is a private property, so there is a question of how to handle this legally, expropriation or whatever. So many different interesting questions from different angles of the law, but it is not just the law, it is much more than this. So I would like to close the conference and take this opportunity to wish you all good, healthy Christmas time, and I hope to see you soon in the next year. So all the best for our speakers, moderators, and also our audience. Thank you so much. We are closing now. Thank you.